Thank you for your kind words. I'll take you back in time from what Mr. Duggal said. Well, he has given you a lot about the current trends as far as cyber laws are concerned, cyber security is concerned. I am now on a different topic altogether, which is about the skills. So when you are in law school, you are taught the substantive law, you are taught the procedural law, but you are not given any training as far as skills are concerned. And what are the skills I'm talking about? The skills are when you get a new case to handle. How do you analyze the case? Nobody teaches you. Everybody has his own method. So if you have to travel from here to Connaught Place, probably you'll use Google to find a way. But what if you did not have Google? Or what if Google showed you a traffic jam on the way? You'd be lost. So what I'm going to teach you today is a better structured way of handling a problem when the problem comes to you. So the problem can come to you whether you are a lawyer practicing in the courts or whether you are an in-house counsel. Either way, you will have different disputes, problems, issues, opinions to be given to various stakeholders. So the purpose of this exercise, as I call it, is to share with you a technique whereby you are better equipped to evaluate, analyze a problem, and find a solution. Because that's what we all do all the time. All the lawyers do this only. We are given the problems, we are thrust with emails, correspondence, papers, agreements, documents, and we are expected to find a solution. And we all make an attempt. So let's see if there's a better way of making that attempt. I had circulated to all of you a note. I hope you have been able to read that. Have you got that? A case analysis note? Everybody? Very well. All right. Now, so for instance, when you start working on a brief, one of the important things that you must know is what are the legal elements involved. I'm not using technical jargon. When I say legal elements means if there is an enactment which is involved, you must know, first of all, what is that enactment? What is the act we are talking of, right? That's the first step. Now, once you have identified the act that we are talking of, for instance, in the problem I have given you, and it's a simple problem, you have Contract Act. Now, Contract Act is huge. So you must understand when you are looking at the Contract Act, what are the provisions I need to look at given the nature of the problem. So I have given you a problem which you've all read, which is a contractual problem. There is a contract between two parties. They agreed, one party agreed to purchase, the other party agreed to supply a defined number of windows. And after a certain time, that contract was not fulfilled. The parties met again, they carried out an amendment to the contract, signed an addendum, signed certain terms, and yet the contract was not fulfilled. And therefore, one party has gone to the court saying, oh, the other party has committed a breach, now I must be compensated, right? It is possible, this problem can be twisted slightly to say one party is wanting to go to the court, claiming damages, and they come to you for advice. So either which way, whether the case has already been filed or it is yet to be filed, you would be engaged either by the plaintiff or by the defendant. And therefore, when you get that problem, when you get that case, you need to first of all understand what are the enactments that I need to look at. And within those enactments, now you don't need to read the whole act. So once you read the problem, you need to identify what are the particular provisions that I need to focus on. So we call them identifying legal elements. Now, for instance, if it is somebody's case that there is no concluded contract. Now, you've also read the Contract Act, I suppose. So can anyone tell me how does a contract get concluded? Yes, please. Yeah. consideration, consent, and there has to be an offer also, and acceptance also, right? And acceptance has to be unqualified, unequivocal, free consent. So you are aware of the. So when I say legal elements, these are the legal elements we are looking at. Whenever you are examining, when somebody challenges that there is no concluded contract, so you will go back to the Contract Act, see what are the ingredients to conclude, to arrive at a conclusion that there is a concluded contract. It will also tell you what are the ingredients which are absent in the given facts, which will lead you to a conclusion that there is no concluded contract. So depending upon which way you are, but important thing is you must know what are the ingredients of that particular section that we must find in the given problem to come to a particular conclusion. So identifying legal elements or the ingredients is the first step we must undertake. Now, you are given certain problems by your respective clients. Sometimes they narrate things to you verbally also. They tell you things which have been exchanged on emails, and then there are written agreements as well. Courts just don't believe in what you write in your pleadings. You understand pleadings? The plaint. Whatever you write, the court doesn't believe in it. That's just a pleading. That's just an allegation. But every allegation and every pleading needs what we call as proof. Correct? Without proof, you are nowhere. Remember the fight you had with your siblings or in your class, or somebody tore the page and you promptly showed, here is the torn page. So yes, that's a proof you flashed immediately and somebody believed that yes, you are a victim of a fight. Or you showed, that somebody is scratched, there is a blood coming out. So you showed proof. Similarly, when you go to the court, make your pleadings, that's fine. But the judge will not believe in it unless the other side admits. But usually the other side will not admit. So therefore, what is needed is proof. So we need to have proof. And as you know, proof is of two kinds. Written proof, documentary proof, and oral evidence, ocular proof. Either you have an eyewitness or you have a document that supports whatever you are saying. Now, in order that your story is believed, your story falling within the legal ingredient that you have identified is believed, you must know what are the facts which have to be established. Right? Please don't presume. The judge will not presume. You've seen the photo of the justice, eyes are blindfolded. So, they will not believe in what you say. You have to prove. So you must know what are the facts which you must establish. If you don't establish, you will fail. If you fail, the judge will not believe you and you will not get an order that you're looking at. You must also understand what facts could be established. Not necessarily, because you see, when people are transacting business, sometimes things happen over a phone call, over messages. Now, when you write a message to somebody, it may be interpreted by the other person in a different way as compared to how the judge will understand. So therefore, you will have to establish that, look, you need to read this message, or you need to say that this particular aspect needs to be interpreted in a particular manner. So you can establish certain facts by providing some kind of an interpretation, again, either through the sender or the receiver, to say, look, this is what I had said and this is what I received and this is what was intended. Then, in every fact situation, you will find that there is no black and white. There are always shades of grey. You hit me first, I hit you first. You took my pencil, you took my pen. Now somebody started, and then things aggravate. So there is no black and white. No dispute has black and white. There are shades of grey in between. So it's important for you to know what are the facts which we call as good facts. Good facts are those which help you, right? Because you'll have to show those good facts to the judge. At the same time, there are facts which are bad facts. Bad facts are the facts which are good facts for your opposite side lawyer, right? So it's as simple. What is good for you is bad for the other side. What is good for the other side is bad for you. But having said that, is that good enough? No. Because first thing is we must identify what are the facts which support us. What are the facts which would support our case? We call them good facts. The facts which are staring, which are looking at us, which we find, oh, why did you do this? This is totally wrong. That's the first reaction you have. This बिल्कुल गलत कर दिया तुमने. How could you write this letter? They're bad facts. But you need to not only identify the bad facts, but learn how to deal with them. Because the other side would be arguing those bad facts against you, at the top of their voice and telling the judge, look, this is what they have done. This is totally wrong. So identifying the good facts means the facts which help you. Identifying the bad facts, that means the facts which go against you, and how to deal with them is also a part of case analysis. Right? Now, once you have identified the good facts, you also need to understand and analyze how will you prove those good facts. It's nice to say there is an addendum to the agreement. But what if the other side says, no, this was not a concluded contract? What will you do? You will have to prove something. You'll have to identify what is agreed, what is not agreed, and what is agreed is, agreed in this manner. Some bit of proof will have to be brought in. So it is important for you to then understand what evidence will you bring, what proof will you bring to the court, before the court, to establish a good fact. Because we started from proof, we identified good facts, we identified bad facts. Now we need to understand who will prove that good fact, a witness, a document. And then that will tell you what witnesses need to be called in to give evidence. Now, you see, this is in a scenario where you're going to the court, but if you're in a corporate setup, you will have, different stakeholders within the company who will come and tell you, this is what has happened, these are the documents I have, or this transaction was entered into by so-and-so person, he's an eyewitness, he can come and depose. You will have various scenarios in different setups. But what I'm trying to tell you is some essential skills that you must know and have when you sit down to analyze a case. Now, in the given case that you have seen there was an agreement between the company AB, who's a manufacturer, and the company OP, which is a purchaser. The agreement was for purchase of a defined number of windows during the years 2023 to 25. The OP company was to issue purchase orders to tell the AB company that I now need so many windows, etc. Please supply. And these goods were to be delivered in Bombay or other projects in Maharashtra, because OP did not have any business in any other state. So in the first year, OP procured 3 lakh windows out of 10 lakh promised windows and said, now there is a recession in the market and, too bad, I can't buy any more. So the year 2024 was a blank year. In 2025, after repeated pressures from AB, who had in the meantime manufactured various windows, there was a meeting in July and August 25. Addendum was signed. And after addendum was signed, 3% of the balance windows were purchased. And again, OP said, I can't buy anymore. So AB has filed a case. Now, in this scenario, can any one of you tell me what are the provisions of Contract Act that you would be looking at? Yes, please. It's a bit louder. Lawyers are supposed to be loud. Right. So one legal element you identify is novation, section 62 of the Contract Act, which says a contract can be amended, and once it is amended, the original contract need not be performed. Very well, all right. So let's keep that in mind. Anybody else? Yes, please.
There's also doctrine of frustration, which is Section 56 of the Contract Act,
Right.
where any unforeseen circumstances which is not uh, intentionally done by the party in question can lead to them being not be liable for the damages.
Sure. So you are saying 56 frustration. Can you just read the language of 56? Do you have it on your system?
No, I'll have to open the
Yeah, please do that.
Section 56 is agreement to do the impossible act. An agreement to do an act impossible in itself is void. Contract to do the act afterwards becoming impossible or unlawful. A contract to do an act which, after the contract is made, becomes impossible, or by reason of some event which the promiser could not prevent, unlawful becomes void when the act becomes impossible or unlawful. Compensation for loss through
So
non-performance of
let's
act.
not talk about compensation because we are on the first part. All right. Anybody else? So here, gentleman here says frustration. 56 is what he will invoke. You said 62. Anyone else? Yes, please. Section 57. 37. Breach of contract. Okay. Can you please read that section? I'll read it for you. Or you've got it on your system? Yeah, please read it. You can speak. I can hear you. Don't worry. All right. Anyone else? Any other? Uh, Okay, all right. So we have four scenarios here. Four different legal elements have been identified. Section 62, Contract Act, Novation, 56, Frustration, 37, and 55. Correct? Now, let us just examine each one of these provisions and see how do we, identify our facts with these legal elements, right? It's important because remember, if you have identified a legal element and your facts do not fall within the purview of those legal elements, then your analysis is not correct. Yes, please, yeah. 7. Okay, all right.
Sorry.
So section 7. So let's first see section 62. 62, as you all know, it says if the parties to a contract agree to substitute a new contract for it or alter or modify it, the original need not be performed. So, who said 62? Can you please tell me how do you invoke 62 now? What facts will you bring in to invoke 62?
Situation of market glitch, then at that moment AP's I think CEO or
They had a meeting.
that person came in Mumbai and they amended some sort of kind of risk and kind of terms and conditions. So according to me, it will fall under amendment under section 62.
So, what are the terms which, according to you, the whole contract need not be performed? Because 62 says, if the parties to a contract agree to substitute a new contract for it or to rescind or alter it, the original contract need not be performed. Okay.
then it is not considered as the
New
new
contract. So, what part do you think is altered? Can you please elaborate on that as well?
point eight, the price of goods, the price, they altered price, time period, and the third, C part is that the other terms and conditions remain unchanged.
Right. How about B? How about B?
Sorry, sir,
How about B? 8B.
within 60 days. Delivery period and revising the guarantee charge.
So, as far as A is concerned, the price to be reduced, there is no dispute that the price was reduced. Other terms and conditions, there is no dispute. How about B? Do you think B has novated the agreement? Think about it. I'll come to you. Yes, you talked about frustration. So now let's look at the ingredients of frustration. You read it out. 56 says an agreement to do an act impossible in itself is void. So now when you examine the facts of this case, do you think the parties entered into a contract to do an act which was impossible?
No, sir.
No.
Yeah.
So the first part is out, right? So when we are analyzing and when we put the fact situation into the language of the section, into the ingredients of the section, we will do an elimination process that this will not apply. Let's see the second part.
Right. A contract to do an act which, after the contract is made, becomes impossible or by reason of
Just
some
pause
event.
here. So has the contract become impossible of performance after it is made?
Right. From OP's side, it has, because of the recession part, they couldn't buy the guaranteed,
No. What is impossibility?
which cannot happen.
Because I don't have money in my pocket is not an impossibility, right? Supposing I buy a Mercedes car and I go and pay money and I say I don't have money, they say too bad. So impossibility will not be a recession in the market. That is a market condition. Impossibility has to be something which is external, in the sense, there is a war. You have to deliver the goods across the border. You can't deliver. That is an impossibility. But merely because there is a recession in the market and you don't have money to buy will not be impossibility. Let's read further. So first part, that contract to do an act which after the contract is made becomes impossible will not apply here. Let's see the next one.
Uh, After the contract is made, it becomes impossible, or by reason of some event which the promisor could not prevent, unlawful.
Pause here. Now, has an event happened which makes the contract unlawful? So even this will not apply. Let's read further.
Becomes void when the act becomes impossible or unlawful.
So now the second part also does not apply, right? Okay. So let's move. So this compensation is not applicable here. So now you noticed when you did a case analysis that while it is a very good thought, 56 will apply, but when you actually sit down and analyze components of 56, ingredients of 56, you will come to a conclusion that 56 does not help you because it doesn't apply, right? So the purpose of this exercise is that you first identify what are the provisions I need to look at, identify the components of that provision. We call them legal elements, you can call them ingredients, you can call them components. And once you apply those components to the facts of the case, you will discover that what seemed lucrative at the outset is not lucrative at all. It doesn't apply, right? So 56 is out. Now let's see 37. Let's look at 37. Obligations of parties to contracts. Correct. So now, what does it mean? That OP must perform unless the performance is excused under any law or under the act. Now, do you find any law or contract where performance of OP's obligations, namely, he has to buy windows, is excused? Do you find anything? Yeah. Correct. Right. Correct. So therefore, he was obliged to perform. There is no excuse for him to not perform. So therefore, you will establish a breach. Correct. Now let's see the fourth section that you pointed out. Somebody pointed. Yeah. Huh. No, somebody said 55. Yeah, you said 55. So 55 is again breach situation where the contract is not performed. Right. Now, when you sit down to analyze any problem, it's important to, I'm saying again, repeating, dissect the sections into smaller portions, ingredients, and see whether they help you or they don't help you. Right? So here you identified 4 sections. 62, yes, what is the analysis of 62? Let's understand. That's going to be the very most interesting part of this conversation. So what are the things which have changed? Let's ask ourselves. What has changed by way of addendum? So what has changed? My question is, the rest of the contract remains the same, but something has changed. What has changed is what I would like to know from you. Limitation period for what? Delivery period is what you want to say. Yes. So has delivery period undergone a change? How did it change? No, let's pause here. You see, when I say analyze, you analyze every sentence, right? So you were thought of a change in delivery period. I want to understand from you, has the delivery period changed? You're saying yes. Now please look at the problem and tell me what is the change. See, it's very important to know your facts. Because, you can, as lawyers, we can never go on assumptions. Very important. So please read, everyone. Please read and tell me if delivery period. Yes, you wanted to say something. So what is the legal element that you want to bring in here? How has it changed? Can you please elaborate? Sure. Yeah, we are talking of section 62, novation. She put a point across that I will invoke novation. I will identify elements of novation in the facts of this case. So we are looking at how will novation apply to the facts of this case. One is price is reduced by 2.5%, para 8A. There's no difficulty, price has reduced. The second is B, within a period of 60 days from the date of the addendum, both parties will mutually agree on amendments to the delivery period and revising the guaranteed quantity of goods to be taken delivery of by OP. So, what is the change which has taken place?
Only the price, sir.
Only the price?
Because the mutual agreement to change and revise other conditions never came to fruition, because after that we don't see a sort of an agreement also changing the terms and conditions of delivery and other things, because after that a suit is directly filed.
So what you are saying is there is no change in the delivery period and there is no change in the revision of the guaranteed quantity. All right. Okay. So very well, let's keep that in mind that 62 will have limited application only in terms of price of the goods has been altered, reduced by 2.5%. But we don't see any agreement on revision of delivery period or reduction in the guaranteed quantity. Do you all agree, or I'm not repeating, I'm just repeating her version. Do you all agree, or some of you may have a different take on
Also,
this?
sir, I want to add one thing,
Yes,
that it is a settled law that commercial impossibility does not translate to actual impossibility.
very well.
Just because it's going to cause you losses does not
Right.
dissolve you of the obligation to perform a contract.
Sure. Yeah. Let's focus on this. Does everybody agree with this proposition that delivery period, despite 8B, remains the same or there is a change? And there is no change in the revision of the guarantee quantity of goods? Or can you speak a bit louder, please? Please take your time. Not to worry, because anyone from this side, anywhere, the backbenchers. I was always a backbencher, and I'm very happy to see a lot of them.
So can I also add one more aspect to this? Because since they agreed that these two terms of contract will be sort of mutually agreed upon in the coming 60 days. So there was a mutual agreement to sit and discuss these terms of contract. And that was a period of 60 days. And this happened on 10th, uh, 10/8/2025. And so it's never mentioned that something like that came into being, but it could have been possible. It could be sort of argued in court that these terms of contract could have remained suspended, because it does say that all other terms and conditions of the agreement to remain unchanged.
So you are saying, although it is mentioned in the addendum that within 60 days we'll carry out these changes, but still there is no change because it's a written contract.
So
The addendum is
technically
also
there is no change, because any alteration or novation has to happen substantially in order to give the effect that the original contract does not exist anymore and that there's a new contract in place.
okay.
And for that, the most important element is the consensus item, or the meeting of the minds for any contract to take place. So
So
if you look at the
what is lacking here? Because they both agreed we'll change it in 60 days.
So the mutual agreement to actually change those conditions and to arrive at the different conditions has remained unchanged. So if you look at it technically, nothing, only the price has changed, nothing else has changed.
So do you think any provision of Contract Act will help you here? Because some lawyers on the other side will possibly argue, oh, there was an agreement, within 60 days things will change, and therefore they can't insist now that you should have taken delivery within a particular period. So you are in breach, AB is in breach, somebody
Sir,
can argue that.
Sir,
So-
we could also argue, so that is also a valid argument, but we could also argue that technically, since there was no discussion, how do you know that something might have changed in, in that
So
discussion?
is there any provision of Contract Act which will come to your rescue, is what I'm saying. Fact situation you have seen. We are identifying the legal elements because ultimately the judge has to decide in accordance with law. Right? So if you see the Contract Act, is there any provision of the Contract Act that you will invoke to buttress your argument that nothing happened, 60 days passed by? They will say it's a signed addendum. How can they go back on it? Right? So they have signed the addendum.
So section 38.
Section
38
What does it
actually says that where a promiser has made an offer of performance to the promisee and the offer has not been accepted, the promiser is not responsible for non-performance, nor does he thereby lose his rights under the contract.
No, but see, this situation arises when there is a contract. But you're saying there's no contract here because they've not arrived at an agreement. That's what your plea is.
So my argument is that the only altered contract that has come into place is with regard to price only.
Correct.
So if we look at the pricing of the deliverables, that is the only changed aspect. So we do not or we cannot argue that the discussion on the other aspects of the contract could have brought a change. It is very well it could have been a possibility that the discussion might not have changed those terms of the contract because that is not a contract in place yet.
Point taken. The point is to your opposite side lawyer will argue that look, there is a signed contract within 60 days delivery period will change. They are in breach by not changing the delivery period. So how will you counter that argument? Which provision of Contract Act will you show to buttress your argument? Have you seen the Contract Act?
Yes, sir.
Please look at it again. Identify that provision. That's the whole purpose of this exercise, that you look at the legal elements and see what you are saying. How will you prove it? How will you establish it before the judge? Does anybody have an answer?
So
Yes.
section 10.
62, yes. Novation. But has the delivery period been novated is the question. Is there a change in the delivery period? She's
Section
arguing.
10. So
Sorry?
I could invoke section 10 essentials of a valid contract.
Let's see
there has to be an offer and acceptance of that. If that hasn't been made in any sort of agreement, how can we say that?
So what is the offer and what is the acceptance you would like to
So
argue?
that is what I'm saying. There is no offer and there is no acceptance. So the only agreed alteration that has taken place is the pricing.
Okay.
There
All
is
right.
no other
Sure.
agreement for that.
Let's hear. Yes. So therefore, what provision
Sir,
of Contract Act would you invoke
Sir, may I?
to say that there is no agreement on delivery period? 29. Okay. Can you please read it? Just please read it. Right. So, can you say that there is a certainty that delivery period is reduced? Answer is no. Right. So this agreement, whereby we agreed to sit together within 60 days to arrive at an agreement, is uncertain. But there is another aspect which is very fundamental. If you just go back to section 2 of the Contract Act. Yes. Section 2G. Just please have a look. Can anyone please read it to me? Correct. Now, supposing OP were to go to court against AB and say that in the addendum they had agreed that within 60 days we'll agree to change the delivery period. And AB has not come forward to discuss. Now you must direct AB to come forward and discuss with me. Can this be enforced? Answer is no. Because it's not certain. Right? If it is not certain, then it is not enforceable. And if it is not enforceable, then it is void. So therefore, section 2G, look at the components of 2G. An agreement, it is an agreement that we will change within 60 days. Not enforceable by law. You can't enforce it. Why? Because it is uncertain. There is no consent to redefine the delivery period. Therefore, it is void. So you need to therefore analyze provisions of law in such a way that you can fit your facts within the parameters. That's the purpose of the exercise we are doing now. Yes, you wanted to say something? Yeah.
I was saying 29, but can we also add 31 by chance in this?
31.
Contingent. The fact that it would, within 60 days, where they would change the guaranteed amount. And so if they have not changed, so it may be subject to the
No,
fact that.
contingent is if see what is a contingent contract? It's a contract to do or not to do something. If a future event happens or does not happen, but that is not the contract here because 60 days are bound to happen.
No, but the change within those 60
Right.
days.
So it says if a future event happens or does not happen. So it is contingent on that. But this is not a contingent contract. 8B is not a contingent contract. It's an agreement, but not enforceable by law. Right? Because it is uncertain. There's no offer and counter offer which has come.
So it won't be a contingent contract.
It won't be a
because
contingent
it's not a contract in the first
yeah.
place.
So therefore, if you are looking at contingent contract, you'll have to dissect because contingent contract is a contract. Therefore, it has to be first established that it is a contract. Now just read 2H. Please read 2H. I'll tell you why I'm saying what I'm saying. And yeah, so contingent contract is a contract, but your 8B, para 8B is not a contract because it is an agreement, not enforceable by law. It becomes a contract only if it is enforceable by law. So it does not cross that threshold of being a contract. And if it does not, yeah. So, yeah.
There was, after this addendum, there was a supply made and there was a payment made.
Correct. That was at a reduced price. Correct.
So that addendum was acted upon.
Correct.
And the addendum said that, the previous terms will continue to
Bind us.
bind us. So if a new term has not been acted upon and the old term is being acted upon and the period has not been reduced, would not the old terms continue to...
Yes. Old period will govern. Old guaranteed quantity will govern. Exactly.
So then there can be a specific performance.
No, the specific performance of the previous contract. Not one party cannot argue that there was to be a change in delivery period. You can't sue me for breach of not buying it. There was to be a change in the guaranteed terms. You can't sue me for not buying the guaranteed quantity. So unless parties arrive at an agreement that okay, delivery period is now altered from this to this, there cannot be any novation. So 8B is not novation. Novation is only 8A. 8B is not novation, right? It's only alteration, rather. So you saw legal elements play a very important role in your journey when you get the facts of a case. You must learn to identify the components, the ingredients, and see whether the facts of your case fit into that ingredient or not. Otherwise, what will the judge say? What are you talking? It's absurd. How can that happen? He'll not believe you. Right? So that's the first step of our analysis, legal elements. Then we move to the next one. Now, supposing all of you are lawyers for the company AB, the manufacturing company, and you were asked to identify what are the good facts. So can you just someone narrate any good facts that you see that support you, that help your case? You filed a suit in the High Court claiming money for breach of contract.
It's a failure of performance.
Failure of performance? All right.
Guaranteed.
So, yeah, you wanted to say something? So, what is the good fact you are identifying here? So, who is at fault in your analysis? OP is at fault. So, OP did not buy the ordered or the contracted quantity. Okay. Yes, anyone else? Yes. Yes. Oh, yes, important. So, according to you, the suit should have been filed at Bombay. So, the filing of suit at Delhi is a good fact for you or bad fact? You are AB's lawyer, please don't forget. We are doing this exercise where all of you are AB's lawyers now. So that will take us back to the previous topic, legal elements. What are the legal elements you would look at to define jurisdiction?
Section 20 of CPC.
Yes, 20 CPC. Yeah, where the contract is. Where was the contract formed? You see, that's the problem.
Sir,
Come to a conclusion before reading the facts. No, what operations? Manufacturing? No, okay. So what does Section 20 say? Because that gives you the right to invoke the jurisdiction
Only
of a
the
court.
cause of action,
Cause of action.
where the cause of action or where the defendant's business resides.
Correct. So where is the defendant here? Who's the
OP.
defendant? Bombay. So,
sir,
and just there is a twist in the tale. There is an explanation to Section 20, which you've not read possibly. If you read that, that will complicate your life a little more. So idea is not to complicate life, friends. It is only to, tell you that we need to read the provisions very carefully. And when you read them carefully, you will realize that there are many nuances, there are many things that we need to really understand and look at before we come to a conclusion. Right? Now, we were looking at the good facts. So somebody said failure to perform, somebody said breach. What else? Is there any other good fact?
So the fact that while the agreement after the sort of the how the agreement came into existence, OP had given an assurance that it would issue delivery orders for purchase of at least 500,000 aluminium windows.
Okay.
And these windows were also highly in demand, and so we could also say that there's a lot of damage or loss that has happened because we were assured that these windows would be picked up by the other party, and we had to manufacture, we had to put in a lot of resources for making those windows, and that's why we have also sustained a loss because we were sort of keeping our end of the contract, and they gave us an assurance, but they did not,
Okay.
like that's a warrant.
All right. So you said they assured to purchase a fixed amount, number of windows. They did not. Right? Okay. Anyone else? Any other good fact that you find for AB, for the manufacturing company?
Also, sir, the fact that we had agreed to reduce the price of goods, that would, because we were like, no, we still want to, perform the contract, and, we're sort of keeping our end of the bargain, and that is why we have given you this leeway of at least reducing the price of goods, but you still did not deliver.
Okay. All right. So reduction of price, good gesture on my part. Yeah. Anyone else? Yes, please. So, volume. Sure. So the good fact that you would like to identify is that I have manufactured an inventory which is lying with me, and therefore I must get compensation for that. All right. Okay. Anyone else? That's
Also,
it. Yes. Yeah. All right. Hmm. 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 Sure. Okay. All right. So written contract, you manufactured, you suffered loss. The good facts you've identified. Very well. Anyone else?
AB has also shown his diligence by asking OB to take delivery of the guaranteed quantity of windows as per the agreement.
Hmm.
He has shown his diligence for that.
So are you for AB or OP?
AB.
Huh.
AB has shown his diligence to asking of the OP to take the delivery amount which is
Okay. All right, sure. Now, having identified these good facts, let us test them whether they are actually good or they are so-so or they are bad. And do we have any evidence to prove it? So somebody said, you said breach of contract, right? What is a breach that you want to say? What is a balanced quantity?
So one
Just one moment. Yeah. Sorry, can you please speak a bit? What is a leftover quantity? Calculate. You're the lawyer.
7 lakhs.
How many?
7 lakh. 7 lakhs. 7 lakhs.
7 lakh. So AB's lawyer here says 7 lakh is the balance quantity. Anybody else has a different quantity in mind? 1 lakh 95. Anyone else? So 7 lakh, 1 lakh 95,000. Anyone else has a different quantity in mind? Because you have to prove. So now, now 1 lakh 90,000. You have to prove. Remember, as I said at the outset, the judges need proof. So one person will say 7 lakh is the unsold quantity, unlifted quantity. Somebody else is saying 1 lakh 90. Somebody is saying 6 lakhs?
6,65,000.
6 lakh 65,000. So you see, in this room, on the same sheet of paper, I have given you facts. You are getting 3 different figures. 4. 3 or 4, yeah. Now, what will you prove to the judge? Who is to be believed? 7 lakhs? 6 lakhs? 1 lakh? Okay, let's ask the first one. Who had said the first one? You had said.
Take it back.
You take it back?
Yeah, that's
Okay.
not 5 lakhs, or almost 2 lakhs. 5.
No. Give me the exact number. I have given you, in my problem, I have been very precise. You can't be approximate. You give me the number. Please calculate it in your mind or on your paper and give me the number. Yes. Somebody said 1 lakh 90,000 here? You said, yeah. How do you come to that figure?
Because it had assured that he will take at least half million.
Correct.
And 3 lakh was already has been delivered.
Right.
Remaining 2 lakh and 2 lakh, on that 2 lakh, 5% has been done. So the remaining is 1 lakh.
1 lakh 90,000. So that's how you will prove your case, that he had to pick up balance 1 lakh 90,000, which he has not picked up. And you will prove it by giving these numbers. Right, okay. Let's see, anybody else has a different, somebody had 6 lakhs? So,
Sir, final came as 335 after doing the math.
just give me a moment. So you are saying 5% of the balance 7 lakhs 35,000. So 665. So see, he has his own calculation of 665. You have a different one? Okay. 335. How do you work that out? So 5% of what will you? So 5% of what is the quantity that you have taken? 3 lakhs is sold. Out of 5 lakhs, 5% is sold. Are you giving your calculation or somebody else's? All right. So now you have realized that it is not as simple as you would have thought. Right? He has his own calculation. He's saying 500,000 was a guaranteed quantity. You have your own calculation. You will prove to the court 10 lakhs was the guaranteed quantity, 3 lakhs was sold, 5% is a balance, 665 is what I am having. Now the crucial question here is that whether you are suing for breach of contract in not lifting 6,65,000 or 1,90,000 windows, do you have evidence to show that these windows are lying manufactured with you? So that is the crucial question you will have to ask your client or your team, manufacturing team. Do you have these many windows lying with you? Because if you don't have proof, the judge will not believe you. Right? So it is important at the very initial stage itself, when you are preparing for a case, when you are analyzing a case, you must ask yourself these questions. Because if you don't, then you would be in for big trouble when the matter comes up for trial and hearing. Because you will not have anything to prove. Somebody will say, oh, no, those windows are there, we sold it off as junk. We don't have any inventory. Or somebody will say, no, we have only 2 lakh windows left. So it's important to know the evidence beforehand, before you go to the court, that you will use to prove your case. So the purpose of this exercise is that not only think about the good facts, but please look at the evidence also that you will need to prove your case. It's possible you may not be able to prove 6 lakh. The person will say, no, according to us only 1,90,000 is a balance and we have it in stock. So think about it, discuss it, get the evidence before you jump to a suit. Now let's look at the bad facts.
So one more thing we
Yes,
would
please.
be so here.
One
One more thing we would be suing them for is the when OP's inability to and refusal to lift the further quantities after 2023. So that is also where he breached the contract.
Correct.
So
So, of course, breach is established. That's what you're saying.
so but in on the basis of 2 grounds, the quantity and then the timeline.
Timelines as well. All
Yes.
right. Okay. So, what is the effect of not lifting within 2024?
So
Because breach leads to some consequences.
for sure, when we manufactured the windows, maybe yeah.
So, now one moment. Loss of customer. So, what kind of claim can you make when you lose a customer? Or can you make a claim? So, what provision of contract that will you look at when you are looking at projected losses? See, everything is governed by law. The judge is only bound by the Contract Act. Which provision of Contract Act talks about damages? Let's look at it. That's the whole problem. Unless we look at everything in detail, we will just be projecting things. But that's not what we are supposed to do. 73. So can anyone please read 73? Yeah, take the mic and please read it for everybody's
Compensation for
benefit.
loss or damage caused by breach of contract.
Sorry, just slowly. Yeah.
Sorry. Compensation for loss or damage caused by breach of contract.
Right.
When a contract has been broken.
Just be a bit slow. When a contract has been broken.
When the contract
So here the
has been
contract has been broken. Right? Okay. Please read further.
The party who suffers by such breach.
The
is-
party means AB. Right? So let's, idea is when you analyze, just pause. Put your client in the position of party which is mentioned in the language. AB has suffered by such breach.
is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things.
Let's just pause here. Which naturally arose in the usual course of things from the breach. Naturally arose, not artificially. So you'll have to think of the meaning of how have the courts interpreted naturally arose. Right? You can't say, I would have had 10 customers, I would have supplied to them, and I've lost business. Because that is may not be treated as a loss which has naturally occurred. But you can say that he had given me an order, I had kept the windows ready, these are the windows available. Yeah. Right.
So we could show them that other companies had sort of given us orders, but we chose you, we chose to supply to you.
So therefore, question is, what is the loss? Either you would have supplied to him and earned profits, or you are keeping that inventory and not made profits. Loss has to be only one, the defined number of windows that you've not been able to sell. You can't say loss of customer, that somebody may say is an indirect loss or a remote loss. Because please read 73 further. Just read 73 further.
From the party who has broken the contract, compensation for any loss, damages, or damage caused to him thereby, which naturally okay, ये हो गया था, or which the parties knew when they made the contract to be likely result from the breach of it.
Then please read the next sentence.
Such compensation is not to be given for any remote
Remote
and indirect
or
loss.
indirect loss or damage sustained by reason of the breach. So you have to keep in mind that you can't claim damages for something which is remote or indirect. It has to be a direct result of the breach. Right? If you're saying I've lost customers, you will have to possibly show that this is a natural consequence, this is not remote, this is not indirect, which might be difficult for you. So it's important to understand what the loss is, understand the ingredients of what the loss is, and see whether the fact situation that you have at hand tallies with it or not. Market practice is not a yardstick to claim losses. Your losses means the money has not come to your pocket. Your profit is lost. Just can you please read the next part of 73, the third part? It might give you an answer. Someone please read it?
Compensation for failure.
Yeah.
Compensation for failure to discharge obligation resembling those created by contract.
No, just read the explanation below this.
In estimating the loss or damage arising from a breach of contract, the means which existed of remedying the inconvenience caused by the non-performance of the contract must be taken into account.
Correct. So this is called, you would have read mitigation of damages. Have you heard this
Yes, sir,
expression?
mitigation of damage.
Right. So what is mitigation? You
The party.
correct. Sure. So I am OP's lawyer, and I say these windows are very much in demand. You say you have manufactured them, and I was not lifting them. You could have sold it to somebody else. You could have given a notice, lift it, or I will sell it. So you did not mitigate your loss. Why should you get any compensation? Right.
Sir, if
Right. So as I said, there is nothing in black and white. Remember, everything is multiple shades of grey. And you are seeing that shades of grey are now emerging. Yeah. So therefore, OP's lawyers will argue, and that's when we move to the bad facts. Yes, you wanted to say something.
yes, a bad. So you can continue. I wanted to add to what she was saying, but in this case particularly, I was going to say this when we were going to discuss the bad facts for AB. But the thing here is that they're also supposed to manufacture the windows when ordered, when the
Yes.
order was given,
Yes.
and advance was to be paid before, and order was to be given, and time to time.
Okay.
They had to lift the entire amount by the 2025, but not specifically in which month or which year until they ordered. So the fact that they manufactured the windows before the order is not OB's fault.
So now let's look at the good facts of OP. So far we were jubilant with OB. Now let's derive some OP. Yes, please.
But we would get huge inventory space was occupied from
from 2023 and 2024, before till attendance was made, so we would get the amount for that, no?
So,
Our inventory space was very much occupied.
so you have to, so therefore you'll need to show that A, there was inventory, number two, there was space occupied, and number three, rental of that space, or, some market rent, right? So keep that in mind. But now let's look at the good facts of OP. Now, the OP in every one of you is awake. Let's see what OP is saying. Yes, you wanted to say something?
So one,
तो अगर रिसेशन आ गया है तो आपको क्या कानून मदद करेगा कि आप अपना ब्रीच करो और बोलो कि सॉरी आई विल नॉट पे डैमेजेस? रिसेशन आ गया, इट्स टू बैड. इट्स but will it help you in a contractual position is the question. See, you are bound by the contract, and therefore, if you want the performance to be excused, remember somebody read section 37, unless it is excused, lawfully excused. So, what is a lawful excuse? Somebody had said 56 Contract Act frustration लगता नहीं है, तो आप कैसे अपने आप को छुटकारा दिलाओगे? सोचना पड़ेगा ना. Yeah.
So, sir, the very first thing, it's itself mentioned in the contract that everything will be on delivery orders to be issued from time to time. That whenever they will place an order, they'll only that can then they will get the supplies. So it's the one of the most important point to be noticed.
So therefore, so from OP's point of view, a good fact is that you never issue delivery orders.
Exactly, sir. Yes.
Okay. So, yes.
Financial performance is already completed by the side of OP, because when OP lifted the
3 lakh.
3 lakh windows by the end of 2023, it constitutes to a significant portion of the guaranteed quantity, demonstrating the bona fide intention by
So,
OP.
is substantial compliance good enough?
It is not good enough.
Come out of breach?
But OP constantly was also trying to communicate and communicate with AB in terms of the contract. He didn't abandon the contract completely.
So, is
Which
there any
also
provision
shows-
of Contract Act that helps you to escape liability under Section 73?
Just come back to you in 5 minutes.
Okay, all right. Okay. Yes. Yes, please.
Sir, it's written in this that the CEO, the Vice President, Krishna Kumar and Ravi Kulkarni, in July and August 2025, they had discussions. They talked about the recession that was about to come. They had a threat. They assessed that threat. And it's also written OP asked for extension of delivery period considering the recession in real estate market, to which AB assured to look sympathetically. So we can say that it's kind of an assurance.
So, is sympathy, waiver of performance?
No, but they had these meetings, so it was intent.
So meetings take place because AB says, I have a lot of goods lying, let's meet, let's plan out how will you take delivery, etc. Meetings always take place because, as I said, everything doesn't happen as per the written down version. Yes.
right, sir. So next we talk about the jurisdiction aspect.
No, let's first discuss.
Acha, I was-
Good fact from
the
OP's
good
point.
fact from
Yeah.
OP, yeah. So the jurisdiction aspect, considering the fact that OP is based in Mumbai, and if I were to cite Delhi, ABC Laminate versus AP agencies, which was a case where Supreme Court, if I could just read out an excerpt from this.
Which judgment are you reading?
ABC Laminate versus AP agencies.
1989 Supreme Court?
Right.
Yeah, tell me. Which para? 10?
No, sir. I don't
Well-
have the paragraph numbers here, but in a suit for damages for breach of contract.
Please read para 10.
So I don't have it paragraph wise. So I just had the
Okay.
one
Okay.
that I thought was
All
sorry.
right.
in a suit of damages for breach of contract, the cause of action consists of the making of the contract and of its breach, so that the suit may be filed either at the place where the contract was made or at the place where it should have been performed and the breach occurred. So in this particular facts, there's no one written where the contract was. They just said that they entered into a contract, but where was it made? There is no place specified.
So therefore, that's a question you need to ask your team in order to in order to say that contract was not signed at Delhi but in Mumbai, and therefore Delhi has no jurisdiction because you're OP's lawyer today now.
No,
So
sir,
you will have to lead evidence.
There is no in the facts. There's no one mentioned where the contract was signed in the
Right.
first place.
It may not be mentioned, but you can always lead evidence to show where it was signed. Somebody would have flown from Delhi to Bombay or Bombay to Delhi, right? You would have air tickets to show. You would have emails exchanged that we are coming on this day to sign.
But so my current argument would be that it also says or where the breach occurred.
So
the
what is the
occurred
breach here?
Breach occurred when there was no lifting of the supply. So it
So,
falls under
so
odd
breach
delivery.
breach occurred in not doing what?
in
Not placing the delivery orders.
but not that is not a breach, sir. How is that a breach? The breach is not lifting of the
Breach is no lifting will take place because you have to. If you look at the contractual mechanism, there is a delivery order to be placed by OP. If OP does not place delivery orders, and delivery orders have to be placed on AV at New Delhi. If OP does not place delivery orders, there's no question of lifting. OP has to pay money,
so even in that
transfer
case,
it
the breach has
online.
happened where the OP is present.
So you'll realize that when you think some fact is a good fact and you start analyzing it, it might turn out to be a bad fact. And therefore you'll have to learn to deal with it. Yes, yeah.
Sir, as an OP lawyer, it has mentioned in para 4, OP was to pay for goods in advance at the time of placing delivery orders. So when the 3 lakhs window has been ordered, the OP has first paid in advance, then has placed the order.
Right.
So in this case, he has neither paid in advance. So in anticipating, it is a bad fact for the AP. And the second thing I want to mention is that a contract was never formed. Just my point of view, because it is a kind of a standing offer. By reading the tile number 3, it issued that during the during the year of 2023-2024 and up to 31/12/2025, based on delivery orders to be issued by OP from time to time.
So therefore, what you are saying is that we had arrived at an agreement to freeze the prices and the quantities, but actual delivery was to take place only when I issued a delivery order.
Yes.
And without delivery order and money, there was no question of he preparing any goods or I taking delivery of any goods. So that's a good fact for you, is what you're saying. All right, we'll keep note of it. Yes. So you can possibly argue if right. So therefore, that is a defense you are raising to OP's argument that delivery order was a mechanism which was put in place to ensure to streamline deliveries. Contract was firm in terms of quantity, in terms of period during which the so you know the beauty of this exercise is that when you start analyzing the case, when you start analyzing the facts, you will realize that there is possibly an argument to counter the argument raised by the other side. But important thing is you need to learn how to deal with that counter argument or the argument. And what evidence will you need to demolish that argument, right? Now, one more thing I want to point out, because I think then it's time for me to wind up as well. If you please come to my note which I have circulated, which all of you have, and if you please come to page number 2, section 1, page number 2. Have you got it, all of you? Yeah. So after you have done a case analysis, what is it that you are supposed to do? You are supposed to prepare a battle plan. What is it that you're going to tell the court? If you are AB's lawyer, possibly your case theory could be, my lord, it's a case of breach of contract, right? It's a case of non-performance. It's a case of non-fulfillment, whatever. Or if you are OP's lawyer, your case could possibly be that, it's a case where there was no concluded contract in terms of delivery orders. Therefore, there's no question of breach. The supplies were to take place only when I placed a delivery order. Depending upon the fact situation, you have to have a case theory or a battle plan in mind, because that will help you determine the route that you have to take. Please remember, you can't be floundering in the court on the last day, oh, what should I argue now? So you should be focused and fixed that, okay, my case theory is going to be a case of breach, or my case theory is going to be a case of novation, or my case theory is going to be no novation, right? Whatever is your case theory. But once you have evolved a case theory, there is a litmus test which I am giving you today. You understand litmus, I am sure all of you have gone through the blue and the reds of litmus. So please come to para number 8. And you must test your case theory on these parameters. And if you fail on any one of those parameters, let me tell you, judge will not be persuaded. First is, it should conform to law. So you saw the legal elements from where we started. If you are arguing anything which does not conform to law, you will fall flat, because the judge will not agree with you. It should not require the court to discredit a credible document. You can't stand up in the court, there was no agreement. Can you do that? No, it's a credible document, you've signed it. So that should not be part of your case theory. If your case theory is there was no agreement, we had open transactions, the judge will not believe you. The third, it should not require the court to disbelieve a credible witness. So sometimes you have these witnesses who come, let's say, from neutral sources. You can't tell the judge that don't believe him. The judge will say he has no interest in the subject matter. So how do I not believe him? Right? So you must test your case theory constantly on these parameters. Fourth, it should be reasonable. You always talk to each other, be reasonable. Right? The judge is a human being like us. If you put a case theory, if you put an argument which is not reasonable, judge will not be with you, he will not bite it. It should accord to common sense. We use this expression all the time. The judges also test your argument on the anvil of common sense. Is it commonsensical or not? Please test it, always. And it should be ethical. It should not involve anything which is unethical in putting that argument before the court. So with that, I would like to end my session. Thank you very much. You've been quite an enthusiastic crowd.
Sir, I have a question.
Yes, please.
Sir, I just was reading the fact, as an AB lawyer, how you will defend the jurisdiction?
How will I defend the jurisdiction?
Yeah, because the suit has been filed in Delhi.
So payments were to be made in Delhi. They were made in Delhi. Contract was made in Delhi. I'll have to prove all of it.
But the section 20 clause simply says that where the territorial jurisdiction will be where the defendant.
No. Read C. Clause 20, Section 20, Clause C. Please read it. C. 20C. Where the cause of action wholly or in part arises. Correct me if I'm wrong. Just see 20C.
Further, sir, I would also like to add something in it. Sir, here. Yes.
Sorry.
So I'm getting one more step ahead that since I'm defending as AB's lawyer, I'll go into summary suit, and then I'll also file for a temporary injunction so that my client is on a safer side.
What is a summary suit?
Sir,
What is a summary suit? What are the ingredients of a summary suit? Okay, let's discuss it. Let's test your case theory on the first parameter. It should conform to law. Remember, I gave you a litmus test. Let's test it. How will it fall under Order 37? Is it an admitted liability or a disputed liability? Is it based on a negotiable instrument or a bill of exchange or no? It's on a disputed liability. It's not on an admitted liability. It's not based on a bill of exchange. So how will you bring it under Order 37?
So it's basically for a time period, for a temporary time period, so that we can have a stay on the.
No, sorry. You're talking of summary suit or injunction?
I'm talking about injunction, no?
Injunction. What injunction will you seek as AB's lawyer? What is a permanent injunction? So let me first clarify this to you. A permanent injunction is one where a person is injuncted forever, not during a period. A temporary injunction is one where a person is injuncted for a certain period of time. Right? So permanent injunction is a relief which the court gives after final hearing. Temporary injunction is a relief which the court gives while the proceedings are going on. That's a difference. So, you may or may not. You may file a suit for recovery and file a temporary injunction. What is the purpose of a temporary injunction? Stay on what? What stay will you ask? I want to ask you. I'm AB. I have come to you. Give her the mic, please.
So, for example, I have a property dispute going on, and there's a house on which you and I are having a property dispute. So, I can go for temporary injunction that right now you have the possession of the house. So, I can go for temporary injunction कि जब तक the court does not decide anything,
I should not transfer.
you should
Yes,
not
of
transfer or
course.
destroy that.
Correct.
That is for permanent.
So therefore, just pause here. जब तक court decide ना कर दे finally, तब तक
Or for a certain period of time,
So,
till the next order is passed.
So therefore,
or
temporary injunction is for a
for
defined
a
period.
defined period.
Permanent injunction क्या होता है?
So that you cannot do anything.
Final relief, forever
Yes.
injuncted. Supposing I have a trademark called DAIC, and you also come out with a mic with DAIC. So I will sue you for not only a temporary
You
injunction,
will sue me for permanent
but
injunction.
a permanent
as well.
injunction that forever you will not use this trademark. So that is a permanent injunction,
Yes.
which lasts forever. Temporary injunction has a limited shelf life. Yeah.
Sir, what about attachment of properties of OP
So attachment,
just to secure my clients?
you see, attachment before judgment takes place. I'm not getting into legal provisions because you'll get confused. But just to tell you, when there is a risk that the opposite party is likely to dispose of its assets or flee from the jurisdiction of the court or do any act which will endanger or which will ensure that the assets are not available once a decree is passed. So you can apply for attachment before judgment. That's a term which is used. Thank you, Dr. Prasad. You see, lawyers speak when they are given a brief, but I wasn't given a brief for, well, so good evening, everyone. Honorable Justice Pankaj Mittal, the dignitaries on the dais, esteemed members of GCI, and my beautiful friends. I can only tell you one thing. I really enjoyed interacting with you when we had that case analysis session. And I'm sure, I'll carry beautiful memories of that session with me. When I saw you undergoing this YUKTI internship, it took me back to my day one in the profession way back in 1981. When I landed with a law degree in a city called Delhi. I was from Agra. And I didn't know what a court looked like. I'd never been to a court. And see where you have been, in this internship program, you have been taken to Supreme Court, you witnessed the live proceedings in the court, you have had good mentors who have come and spoken to you and given you a direction in your profession. So, hats off to GCI. It's something which is so wonderful. I was talking to Dr. Gemawat a little while ago. I said, I have never seen this kind of an internship program anywhere in the world. So a big round of applause to GCI. I would only like to give you short 2 or 3 messages and I'll conclude. One, there is no shortcut to success. Please remember, there is no shortcut to success. Two, there is no shortcut to hard work. Three, be honest in whatever you do. And last, be ethical. Thank you.